Now, Michael, I gave a brief overview of what's happened so far. What can you add to the description? And I think for our viewers who might not be familiar with some of these basic concepts, what are the roles of the Competition Bureau and the Competition Tribunal in mergers like this?
Thanks for having me. I'll start with that last question. So the role of the Competition Bureau is to review these proposed mergers or transactions, as they sometimes call them. They're the government agency that acts as an enforcer, and they enforce something called the Competition Act. Then you've got the Competition Tribunal, which is a specialized court, and they're the ones who hear applications or challenges. And the person who challenges a merger is called the Commissioner of Competition, and he or she is the head of the Competition Bureau. So in this case, the Commissioner of Competition, or the Bureau, they challenged the merger between Rogers and Shaw. But in the end, as you alluded to, the Competition Tribunal heard a very fast-tracked case. It took about a month, and they got a decision out, I think, in 17 days. And they said, no, we don't have any competition concerns that competition will be lessened by this. We actually think this merger is going to increase competition, especially in wireless. And there was a bit of a fight over what transaction they were actually trying to review. But in the end, that's what the tribunal held, that it was good for competition.
Keldon, is there anything you want to add to that? And it certainly is surprising that a merger would add to competition. How did they reach that conclusion?
So the argument that the transaction is pro-competitive is that Shaw was in the process of exiting the wireless and wireline businesses, and so really wasn't up to it to make these investments it allegedly needed for to continue to offer wireless and next-gen wireless service. So Rogers has struck a deal with Videotron, a Quebec company, to effectively take over Shaw's wireless business and give it a number of favorable agreements for sort of the inputs to that business. So on the basis of that transaction and those agreements, the parties are arguing that this will actually enhance competition in Canada.
Now, Keldon, one of the things that stood out to me is that the challenge was to the wireless part of the merger, but these companies obviously have more than just wireless services. So should there be broader concerns about the merger, or really should we just be focused on the wireless implications?
Well, I think the wireless focus is a product of how our competition law works. It tends to focus on overlapping geographic markets. So when it came to Shaw's wireline subscription or wireline infrastructure, there was no overlap physically between Rogers' network, but I think that misses a big part of how competition works. It's not just what you have sort of available at your fingertips. It's what you see in other jurisdictions, what kind of services other players are providing, and what you demand of the companies you interact with. You know, Shaw's cable business and home internet business introduced a number of innovations over the years that even players that were not necessarily in its own geographic market eventually followed on. So the wireless focus really is a product of how our competition law works, but I think a broader lens can be appropriate.
Now, Michael, we've only got 30 seconds left in this segment, so I'm going to pose the question to you, but you can answer it in the next segment. I want to understand how the review process works. Like, how do deals like this get reviewed, and what do the companies need to show in order for it to get approved? And you also alluded to the speed at which this happened. And I want to know, can you walk us through that review process and let us know the speed at which it happened? You said it was very fast, but is that speed unusual? We've got to go to break, but I look forward to hearing the answer when we come back.